Assalamualaikum to everyone. For today, we are going to learn new topic under the government's liabilities. This is an interesting topic because this topic will covers on the liabilities of the governments in regards to the contract, tort and military personnel. Okay, first we start with the learning outcomes. The first learning outcomes is first to identify the government liabilities in tort and contract. Second, to apply the provisions under the Government Contracts Act 1949 and Government Proceedings Act 1956 and other relevant statutes in situations that may involve government liabilities. Please take note that we are going to scrutinize the requirements falls under these two statutes, Government Contracts Act 1949 and Government Proceedings Act 1956. And third, to discuss the decisions of the courts in the terms of these government liabilities. Okay, we may refer into the decided cases. Okay, the first subtopic is a government liability in contract. Basically, government is not supposed to take part in business. Hence, the government is not supposed to contract, okay, with individuals. Okay, this is based on the traditional perspective. Okay, however, today the government becomes a role as the protector of the weaker sections of the society, and then the government itself introduced statutes that can help the consumers. For example, we have a hire purchase act to give the procedures to provide the formalities in order to have a valid hire purchase agreements. Hence, the government's involvement here we will relate into the people's day-to-day activities is undeniably necessary. So we cannot deny that the government also will involve into the daily situations of the citizens. That's why today the government does make contracts with individuals or businessmen. What is a contract? Based on the legal definitions of contract, according to Section 2, subsection H of the Contracts Act 1950, contract is an agreement which is enforceable under the law. In order to have a valid contract, it must fulfill all the elements of a valid contract. I believe that you guys still remember what you have learned in your commercial law before this. Okay, or some of you have learned Law 299, business law. The elements of contract, for example, the capacity of person, offer, acceptance, considerations. These are the basic elements that are necessary in order to form a valid contract. Right? So based on Article 69, Clause 1 of the Federal Constitutions, the Federation has power to acquire, hold and dispose of property of any kind and to make contracts. Based on these provisions, it shows that the government may enter into a contract to buy a property or to sell the property. For example, Reza has a land in Alopongso. The state government of Penang is interested to buy his land at 1 million ringgit. If Reza agrees to sell the land, he is said to make a contract with the state government of Penang. Now, there was a contractual relationship exists between Reza and the state government. Reza agrees to transfer his land to the state of government of Penang, and the state governments of Penang must pay him 1 million ringgit. However, if the state government of Penang fails to pay Reza as promised, Reza could claim against the state government of Penang, and if Reza succeeds in his claim, the government is said to be liable in contract. Okay, based on these illustrations, it shows that the law also governs the contractual relationship between governments and individual person. Alright, in order to make the government liable in a contract, we must take a look into these two statutes. First is a Government Proceedings Act 1959, and second is Government Contracts Act 1949. First, we take a look at the Government Proceedings Act 1956. What are the requirements that must be fulfilled in order to make the government liable in a contract? First requirement is under Section 4, subsection C, states that such claim arises out of any contract made by the authority of the government, which would, if such claims had arisen between subject and subject, afford grounds for civil proceedings. So the contract made between an individual and the governments are enforceable, provided that the contract must be made by the authority of the government. Okay, so it is also similar to the contract made between two individuals. Any breach of contract will allow one party to claim against the other. For example, if landlord contracts with the federal government to sell his land, so the rights are the same as if the contract is made between landlord and Galahad, another individual. These illustrations to tell us that even you enter into contract with the governments, the law is also govern your contractual relationship. The law is similar as it governs the contract made between individuals. Hence, if landlord does not get paid from the federal government, he can claim using the relevant laws. Like in this case, situation, he must look into the requirements under Government Proceedings Act and Government Contracts Act 1949. The second requirement is Section 29, subsection 1, states that the specific performance cannot be granted against the government, but in lieu thereof, the court may make an order declaratory of the rights of the parties. What is specific performance? Specific performance is a remedy for breach of contract. Okay. It is an order granted by court in order to compel a party in a contract to perform his contractual obligations. However, if you enter into contract with the government and then the government breach the contract, you cannot apply for specific performance. But in lieu here means that in replacement. So court give you replacement, court may make an order declaratory of the rights of the parties. In other words, order for declaration. As you can see in the case of governments of Malaysia against Lim Kiat Siang and others, what happened in this case is that the governments granted to the innocent party the remedy of declaration instead of specific performance. Another example, as you can look into based on Section 29, subsection 1, if exceeds contract with the government but does not get his money, SC can go to the court to claim against the government, but he will not be able to claim specific performance to force the government to pay his money. HC can only claim declaration from the court. In example, an order declaring the rights of a person under the law. Order is only a declaration. The order will weaken the government's action because if the government does not act according to the order, they will be regarded as having acted against the law because it is already secured the order from the court. This is where once it's granted this order of declarations, the government will pay him the money. Okay. Okay, next we look into second statute that applicable to the government's liability in a contract. It's based on the Government Contracts Act 1949. Based on section 2, government contracts must be made in writing in the name of the government, and the government officer signing the contract should possess written authority from the government, otherwise the contract will not bind the government in case of breach. Right, class, based on section 2, there are two basic requirements that must be fulfilled in order to claim against the government. First, you must prove that the contract must be made in writing in the name of the government. And second, the officer who signs the contract on behalf of the government must have a written authority to do so. So he must prove that he was instructed by the government in order to enter into contract. Okay. For example, you may refer to the case of Suwiri Sindian Berhad against a government of the state of Sabah. What happened in this case that the contract made by the government's officer here not binding the governments. Okay, the contract is void because the second requirements here is not fulfilled. So in this case is that the contract could not be a valid contract because the officer concerned did not have written authorizations to act on behalf of the state governments. So these two requirements must be fulfilled. Next, okay, the next requirement under the same statute, section 6. Based on section 6, no contract shall be deemed to be made by this authority of the federal government or state government unless they are made according to the procedures laid down in the Act. So they must follow the formalities, the procedures, the manners stated in this Act. For the contract to be valid, all the required procedures laid down in the Act must be observed. If not, the contract cannot be enforceable. For example, must fulfill all the requirements of valid contract. And the last requirements is section 8. No public officer shall be liable to be sued personally upon any contract which he makes in that capacity. So if he enter into contract, he cannot be sued personally. Okay, the one who can be sued is the government because this officer entered into contract with the third party on behalf of the government. However, a public officer shall be personally liable when he expressly pledges his personal credit or where he contracts otherwise than as an agent of the government or of state governments. If he himself agreed to take the personal liability, then the third party may take action against this officer. For example, if he uses his own name or does not mention that he is acting on behalf of the government, then he will be personally liable. This is because the third party may assume that he contracted for himself, for his own interest, not the government's. So in order to enter into contract on behalf of the governments, you must inform the third party. Okay, example of case, you may refer to the case of Macbeth against Haldimans. In this case, the court held that the General Haldimans was not personally liable for the goods ordered for military purposes because the plaintiff, who is the third party, knew that the defendant was contracting on behalf of the governments and he knew that the goods were used for military purposes. So you must disclose to the third party if you enter into contract on behalf of the governments. Okay, that's all the requirements must be fulfilled in order to take action against the governments in contract. Next, we proceed with the government's liability in tort.